Hello and welcome to USSC Live, the United States Sentencing Commission's series of interactive webcasts produced in conjunction with the Administrative Office of the U.S. Courts and the Federal Judicial Center. I'm Krista Rubin.
And I'm Rachel Pierce. Today we're going to focus on the Commission's recent vote on retroactivity of the proposed drug amendment with our guest, Kathleen Grilli, General Counsel at the United States Sentencing Commission.
We'll also discuss alternatives to incarceration and what the Commission has done over the last several years regarding amendments and application.
And finally, Glenn Schmidt, the Director of the Office of Research and Data, will give us a demonstration of the Commission's online interactive sourcebook. It's a fantastic resource for federal sentencing statistics. So, we have a lot to discuss, but we need your help. Please send an email with your questions.
We want to hear from you. Submit your questions in the box below. Just scroll down and you will see the questions box, or as Rachel mentioned, send your question to training@ussc.gov. We will post the email address throughout the program, and we will do our best to answer those questions as we receive them. Okay, let's welcome our first guest, Kathleen Grilli. Hello, Kathleen. Thank you so much for joining us.
Thank you for inviting me on USSC Live.
During this amendment cycle, the Commission promulgated an amendment which reduces by 2 levels the base offense levels applicable to most quantities on the drug quantity table at the drug guideline 2D1.1 and on the quantity tables for chemicals at the listed chemicals guideline 2D1.11. Can you talk to us about what led the Commission to make this change?
Yes. The Commission has the statutory duty to ensure that the guidelines minimize the likelihood that the federal prison population will exceed capacity. Reducing the federal prison population has become urgent, with that population almost 3 times where it was in 1991. Federal prisons are 32% over capacity and 52% over capacity for the highest security facilities. The impact of this guideline change on prison populations, should it go into effect in November, would be significant. We expect that almost 70% of drug trafficking offenders would see their sentence reduced. And for those offenders, sentences would decrease by an average of 11 months. Within 5 years, the federal prison population would be reduced by more than 6,500. Over time, the effects could be much greater. Several other changes in the guidelines and law supported lowering drug quantity table by 2 levels. When the drug quantity tables were set at their current level, above the mandatory minimum penalties, drug quantity was the primary driver of drug sentences. There was only one other specific offense characteristic in the drug guideline. Now there are 16 specific offense characteristics, including enhancements for violence, firearms, aggravating role, and a whole host of other factors to help ensure that dangerous offenders receive long sentences. Quantity, while still an important proxy for seriousness, no longer needs to be quite as central to the calculation. Also, guideline ranges were originally set above mandatory minimum sentences to provide some incentive for lower-level offenders to plead guilty. Subsequently, though, Congress created the safety valve, which provides a much greater incentive for lower-level offenders to plead. In fact, when the Commission reduced guideline levels for crack offenses by 2 levels in 2007, the overall rates at which crack cocaine defendants pled guilty and cooperated with the government remained relatively stable. This recent experience indicates that this year's amendment, which is similar in nature to the 2007 crack amendment, should not affect the willingness of defendants to plead guilty and cooperate with authorities. It is also important to note that the Commission was informed by our studies, comparing the recidivism rates for offenders released early as a result of retroactive application of the Commission's 2007 amendment, reducing guideline levels for crack cocaine offenders, with a control group of offenders who had served their full terms of imprisonment. The Commission detected no statistically significant difference in the rates of recidivism for the 2 groups of offenders. First after 2 years and again after 5.
Now, after voting on the drug amendment in April, did the Commission take any further action relating to drug offenses?
Yes. Because this amendment reduces penalties in the area of drug offenses, the Commission had a statutory obligation to consider whether it should be applied retroactively, that is, to drug offenders who have already been sentenced. To help inform the Commission's consideration of this issue, the Commission directed staff to prepare a retroactivity impact analysis of the proposed amendment, which, among other things, estimated the number of offenders who might benefit from retroactive application of the drug amendment. The Commission also held a public hearing and solicited public comment on the issue.
Kathleen, let's cut straight to the chase. Did the Commission vote to make this amendment retroactive?
Yes. On July 18, 2014, the Commission voted unanimously to make the drug amendment retroactive, subject to a special instruction that any order reducing terms of imprisonment cannot be effective until November 1st, 2015. What this means is that once the amendments take effect, the sentencing court can consider a possible sentence reduction for inmates meeting certain criteria set by 18 United States Code Section 3582C2 and the Commission's policy statement at 1B110.
What is the expected impact of making this drug amendment retroactive?
Rachel, our data estimates that approximately 46,000 offenders will be eligible for a sentence reduction. The average sentence reduction will be approximately 18% or 25 months. The current average sentence is 11 years, 1 month, and the new average sentence is 9 years.
Now, Kathleen, when does the drug amendment take effect?
Rachel, unless Congress expressly disapproves the amendment, it will automatically take effect on November 1st, 2014.
And how soon will inmates be able to apply for a sentencing reduction?
As with the drug amendment, the amendment to 1B110, our policy statement that discusses reductions in terms of imprisonment, will become effective on November 1st, 2014.
Kathleen, does this mean that on November 1st, 2014, we will see drug defendants getting out of prison pursuant to retroactive application of the drug amendment?
No, Krista. The earliest any offender can be released pursuant to these changes is on November 1st, 2015. However, the Commission anticipates that the courts will begin considering petitions for sentence reduction and entering orders granting those reductions as of November 1st, 2014, provided that the effective date of the court's order is November 1st, 2015 or later.
And why did the Commission vote to delay implementation of the reductions in sentence?
The Commission voted to delay implementation of the reduction orders to effectively address risk to public safety, as well as reduce the difficulty of applying the change retroactively. This delayed implementation will address public safety concerns in 3 ways. First, it will allow judges more time to consider the initial influx of motions for reduced sentences and carefully review every case to determine whether a sentence reduction is appropriate. Second, the delayed implementation will ensure that the Bureau of Prisons can give every offender the usual transitional services and opportunities, including halfway house or home confinement, that help increase the chances of successful re-entry into society. Third, the delay will allow the Office of Probation and Pretrial Services adequate time to prepare so that released offenders can be effectively supervised.
Is every drug defendant eligible for a reduction?
Not necessarily, Rachel. There are 3 criteria that must be met in order for a defendant to be generally eligible for a reduction in sentence. First, an offender must be serving a term of imprisonment. Second, the guideline range applicable to the offender must have been lowered as a result of the 2014 drug amendment. And finally, the offender must not already be scheduled to be released prior to November 1st, 2015.
Can you give us some examples of who may not be eligible for a reduction in sentence?
Sure, Krista. There will be some defendants whose guideline range will not be lowered as a result of the Drugs -2 amendment. For example, in some cases involving large quantities of drugs, the drug quantity may keep the defendant's base offense level at 38. In some cases involving very small quantities of drugs, the base offense level may remain unchanged from being the lowest base offense level for the drug type. Another example would be defendants whose offense level was determined by the career offender guideline. Finally, some defendants who did not receive a government motion for providing substantial assistance may have a mandatory minimum penalty that is in excess of the applicable guideline range.
Kathleen, once a defendant is deemed eligible for a reduction, are there limitations as to the extent of that reduction?
Yes, Rachel. The reduced term of imprisonment cannot be less than the term of imprisonment the defendant has already served. Additionally, the term of imprisonment for the previous sentence cannot be reduced to less than the minimum of the amended guideline range, with exceptions in cases involving a substantial assistance departures. Everyone also needs to be aware that in addition to listing the Drugs -2 amendment at 1B110, the Commission also amended 1B110 itself to address a circuit split regarding the extent of a reduction that can be granted in cases involving substantial assistance departures.
Okay, so does the judge have to automatically grant a reduction in the term of imprisonment when a defendant is eligible?
No. The decision to reduce the term of imprisonment is entirely within the judge's discretion. In fact, there are factors in 1B110 that the judge is to consider in determining whether a reduction in sentence is warranted, including the factors listed at 18 United States Code Section 3553A, public safety, and the defendant's post-sentencing conduct.
Now, Kathleen, before we let you go, can you talk a bit about the resources we have available to assist the courts as they consider these motions for reduction in sentence?
We have several resources to assist the courts in processing these motions. First, our viewers should know that the Commission has prepared a list of offenders eligible for the sentence reduction. The Chief Judge or the Chief United States Probation Officer, on behalf of the Chief Judge, can submit in writing a request for the list of eligible offenders for their district. These requests can be sent to the attention of Glenn Schmidt, the Director of Office of Research and Data, who will be joining us on this webcast shortly. Once the request is received, Glenn will send the list via email to the Chief Judge. Second, viewers can find on our website a document that discusses the most frequently asked questions about the retroactive application of the 2014 Drug Guidelines Amendment. Third, we also have a legal primer on retroactivity that has been posted to our website. And finally, we are providing training on the application of this amendment. Districts that are interested in training should contact Pam Montgomery, Director of the Office of Education and Sentencing Practice, to schedule such a training. We will also have another webcast in October that will go into specific detail about the application of this amendment, as well as the other amendments going into effect on November 1st, 2014.
Thank you very much, Kathleen, for all that useful information on retroactivity.
No problem. Thank you.
Again, to our viewers, if you have a question, now is the time to get those questions to us. Simply type your question in the box below us on this page or send an email to training@ussc.gov. Krista?
Thanks, Rachel. Recently, the Commission has identified as one of its priorities for the 2014-2015 amendment cycle the study of the availability of alternatives to incarceration. The Commission's enabling legislation, specifically Title 28 of the United States Code, Section 994J, requires that the Commission shall ensure that the guidelines reflect the general appropriateness of imposing a sentence other than imprisonment in cases in which the defendant is a first offender who has not been convicted of a crime of violence or an otherwise serious offense. Now, consistent with the congressional directive, the guidelines permit alternatives to incarceration for defendants who fall in zones A, B, or C of the sentencing table. Specifically, for defendants who fall into zone A of the sentencing table, the court may impose a fine or straight probation as an alternative to incarceration. For defendants who fall in zone B of the sentencing table, the court may impose split sentences of either probation with a condition that substitutes intermittent confinement, community confinement, or home detention for imprisonment, or a split sentence of imprisonment of at least 1 month of the minimum of the guideline range, plus supervised release with a condition that substitutes community confinement or home detention for imprisonment as an alternative to straight incarceration. For defendants who fall in Zone C of the sentencing table, the court may impose a split sentence of imprisonment of at least 1/2 of the minimum of the guideline range, plus supervised release with a condition that substitutes community confinement or home detention for imprisonment as an alternative to straight incarceration.
Krista, can you give us a little bit of background on what the Commission has done over the last several years in the area of alternatives to incarceration?
Sure. The Commission began focusing more closely on the issue of alternatives to incarceration back in 2008 when they held a national symposium to gather information regarding the use of alternatives to incarceration and to provide a forum for idea sharing concerning possible implementation on non-incarceration sanctions in the federal system. Now, in 2009, the Commission released a publication titled Alternatives to Incarceration in the Federal Criminal Justice System. An important find in the paper was that due to the rising number of non-citizen offenders in the system, the courts are imposing fewer alternative sentences. Additionally, fewer alternative sentences were imposed for Zone C defendants than were for Zone B or Zone A defendants. Furthermore, defendants with a criminal history category were most likely to benefit from alternative sentences. So in the years following, the Commission has promulgated amendments in an effort to expand the use of alternatives in sentencing. Specifically, in 2010, the Commission expanded Zones B and C of the sentencing table by 1 level, allowing for more probationary and split sentences. Additionally, the Commission added Application Note 6 to Guideline 5C 1.1 to encourage departures from the options in Zone C of the sentencing table to the options in Zone B of the sentencing table in order to accomplish a specific treatment purpose, such as drug treatment or mental health treatment.
Now, Krista, can you tell us a little bit about what the plan is going forward as it relates to this priority of looking at alternatives to incarceration?
Sure. Moving forward, the Commission plans to update the data originally reported in the Alternatives to Incarceration in the Federal Criminal Justice System report. The Commission plans to study the recidivism rates of defendants who were given alternative sentences to see what impact, if any, can be found when the courts impose alternative sentences. The Commission also plans to study various diversion programs that have been developed over the last several years. Since the Supreme Court's decision in U.S. v. Booker, an increasing number of courts have exercised their sentencing discretion by creating programs that expand the availability of alternatives to incarceration. So, for example, in the Central District of California, they have the CASA program, which stands for Conviction and Sentence Alternatives. The Central District of Illinois has the PATI program, which stands for Pretrial Alternatives to Detention Initiative. And the Eastern District of New York has the POP program, which stands for Pretrial Opportunity Program. Now, typically these programs are designed for defendants who have mental health and or substance abuse issues. So, Rachel, how about if you tell us a little bit more about how these programs work?
Sure. Typically, these diversion programs allow defendants to participate in treatment programs that are tailored to their specific issues after they enter a guilty plea, but before sentencing. So if the defendants successfully complete the treatment programs, then the court will generally vary from the guideline range to impose a sentence alternative to incarceration, which is typically a probation sentence.
Well, it certainly sounds like an exciting area that the Commission is going to be exploring during the coming months. Now we would like to welcome the Director of the Office of Research and Data at the Sentencing Commission, Glenn Schmidt. Glenn, welcome back to USSC Live. Thank you so much for joining us today.
It's good to be here. Thank you.
Glenn, the Commission has been working on making our rich data on federal sentencing more readily available to the public on our website, USSC.gov. One way the Commission is making more of our rich data, sentencing data available, is by updating the online interactive sourcebook of federal sentencing statistics. Now, before we give our viewers a demonstration on how to use the sourcebook, can you tell us a little bit more about it?
Sure, Rachel. The interactive sourcebook is a great resource of federal sentencing data and is available on the Commission's website, USSC.gov. Each year, the Commission delivers an annual report to Congress, part of which is the annual Sourcebook of Federal Sentencing Statistics. The Sourcebook provides a wide range of federal sentencing data, including data on cases with individual offenders, organizational or corporate offenders, resentencings and other modifications of sentence, and appeals cases. The online interactive sourcebook contains all of the information found in the printed sourcebook, as well as many more tables and figures found only in the online version. And it also allows users to customize all of these tables and figures. For example, users can create tables and figures for one or more particular judicial circuits or districts, change the year of the data being viewed, or combine multiple years into one table. In addition, some of the tables and figures in the interactive sourcebook contain additional viewing options, such as the ability to view the information by primary guideline or primary offense category, or the ability to select different category options.
Wow, Glenn, that sounds great. So the interactive sourcebook basically allows users to customize the standard tables and charts that are presented in the Commission's printed sourcebook. That's a great resource.
It is, Krista, but I think one of its most important benefits is that it includes much more information not currently available in the Commission's printed sourcebook, giving the user access to even more information than ever before.
Glenn, I've personally found the online interactive sourcebook is extremely user-friendly, and I refer to it often. So let's give our viewers a demonstration of what they can do with this program. First, how can people access the interactive sourcebook?
Sure. As you can see from this clip, the interactive sourcebook can be accessed on the Commission's website, USSC.gov. Simply go to the Commission's homepage and click on the Interactive Sourcebook tab at the top of the page. You'll be taken to the homepage for the interactive sourcebook.
Let's take a look now at the interactive sourcebook homepage. What are these boxes?
Krista, these boxes represent different categories of data, organized by topic. At the top left is a gold box. This gold box, when you click on it, will provide users with a list of all of the available tables and figures. But if the user knows the type of information they are looking for, they can simply click on the appropriate blue box that contains the data they're looking for.
It's helpful to have the tables organized by categories of data.
It is. And for additional help, there is a menu box on the left side of the screen, as you can see here. I'd like to highlight two things on this menu. First, there is a features guide. This page provides step-by-step instructions for users on how to access the information in the website. And I'd also like to highlight the FAQs on the menu of the Interactive Sourcebook homepage. The FAQs provide answers to common questions about the Interactive Sourcebook, as well as general information about the Commission and the federal sentencing guidelines. As you can also see, there are links to the Guidelines Manual and information about the Commission.
Glenn, let's give our viewers a detailed example of what the interactive sourcebook can do. Where should we start?
Let's take a look at a table that describes the average sentences based on a defendant's primary offensive conviction. This is Table 13 in the Commission's printed sourcebook, and this table can be found in the category Sentencing Information. When we click on that box, it takes us to the menu for the category Sentencing Information. We click on the plus sign to expand the list of available information, and now you can see the full list of tables under the Sentencing Information category. When looking at the full list of tables, you'll see a blue I button next to each table. This button is an information button, and when you hover the cursor over the I, a pop-up will come up and provide a brief description of the content of the table. Also, you will see that we list the table that we're discussing as Table 13 here, just as we do in the printed sourcebook. And I'll mention that any table or figure without a number or letter means that it is only available in the online interactive sourcebook. Now, when we click on Table 13, the program generates the data in real time using the Commission's data sets. What you see here are the mean and median sentences based upon the primary offense category. Nationally, for example, we see the mean sentence for immigration offenses is 16 months, and the median sentence is 10 months.
Now, you had mentioned that the interactive sourcebook can be customized by users. Can this table be customized?
Absolutely. As you can see on this slide, there is a button with a funnel at the upper left-hand side of the screen. By clicking on the funnel button, a pop-up menu appears and allows users to customize the information by fiscal year, circuit, and district. For this example, we'll select a different fiscal year, and you'll see that the information is changed based upon the new parameter.
That's fantastic. So, for example, if an attorney was looking for the average sentence in drug offenses in his particular district, he would use the funnel button and simply select the district in which they practice to get that information.
Exactly. And it only takes 2 or 3 mouse clicks to get that information. Users can even save and print out the results of their inquiry in a PDF format.
How about another example? Earlier, we talked to Kathleen about the retroactive Drugs -2 amendment. Let's take a look at an example of some information related to drug type.
Sure. In this example, from the Interactive Sourcebook homepage, we'll click on the category Drug Data. Again, we'll need to click on the plus sign to reveal the list of tables available in this category. As you can see, the information buttons I described a few minutes ago are there as well. For this demonstration, we're going to go to Table 34, Race of Drug Offenders in each drug type. After we click on the link for Table 34, the Interactive Sourcebook provides the race of offenders broken down by the type of drug involved in the offense. Again, we'll use the funnel button to customize the chart according to new parameters. In this case, we'll select a particular district. The online sourcebook then generates the data according to the new parameters provided by the user.
Now, Glenn, so far we've seen examples of how to customize charts and tables that are already contained in the Commission's sourcebook. However, you mentioned earlier that the interactive sourcebook also contains charts and tables that are not included in the printed sourcebook. Can you give us an example of one of these tables?
Yes. I'd like to highlight the trend analyses that we have online. These charts describe individual offender federal crime data across multiple years. Again, starting from the homepage, we'll click on the Trend Analysis category. We click on the plus sign to show the list of tables and figures available under this category. As you can see on this list, none of these trend analysis tables are in our published sourcebook. These are all unique to the online data. For this example, we'll select the table describing the number of cases over time. The website defaults to a 6-year time frame for this analysis, but users can use the funnel button to select a different set of years, and also to select specific districts or circuits to examine. And by clicking on the wrench button or the rainbow button at the top left of the page, users can even change the scale used for this figure, or even the color of the line on the chart.
Glenn, thank you so much for being on today's program and for taking us through all the great features the interactive sourcebook offers.
Thanks again for having me.
Well,
we actually received a question, and I think that it's a question sort of on the first part on the retroactivity regarding the amendment, but it's also sort of a data question. So we're going to ask Glenn. The question comes in from Ellen Moore from the Middle District of Georgia, and her question is there going to be a standard form for the orders that come out as a result of this retroactivity amendment?
Yes, several years ago, the Commission worked with the Judicial Conference of the United States to create AO Form 247, and that is the preferred form for courts to use when documenting their decisions in motions to reduce sentences under the retroactive application of any Commission amendment that has been lowered.
Great. Thanks for answering that for us, Glenn. Well, that's all the time we have for today. Thank you, Kathleen Grilly and Glenn Schmidt, for visiting with us. We've updated you on recent Commission business related to the retroactivity of the drug amendment. We've highlighted some issues regarding alternatives to incarceration, and we provided a demonstration of our interactive sourcebook.
Also, thank you, our viewers, for joining us. Please take a moment and give us some feedback on this webcast. Also, don't forget to let us know if you have any suggestions for future webcast topics. We'll see you next time on USSC Live.